Okay. Lisa, you're doing good so far. Basically, what we're talking about, the concept of property, land improvements, rights and privileges, and we spent an inordinate amount of time talking about rights and privileges, appurtenances. So, Lisa, here's the question for you to see if you paid attention in the first 10
Uh-oh.
minutes. Um, are appurtenances, is an appurtenance real property or is it personal property? What do you think?
Real because it runs with the land.
It's real property by definition. It runs with the land. So see, that wasn't that hard after all. Okay. All right. Continuing on with this section, and notice we're still talking about the concept of property. So all we're doing is defining the property. This gets a little bit fun right here. We're going to move through it fairly quickly until I tell you we're at it. Something that's more difficult. Okay. So real property versus personal property. Let's start this conversation by talking about what we refer to as fruits of the soil. Now, every once in a while, we like to throw in a little bit of Latin lingo just to make us look smarter than what we are. But this is the case here. Fortunately, the words look like what you would expect they mean. So when we're talking about fruits of the soil, things growing in the soil, look at our first category, fructus naturalis. And I don't speak Latin, so I don't know if I pronounce it correctly or not, but you see the spelling there. So does that, when I read that word, I look at it, it's like natural fruits, things that are naturally growing in the soil. I didn't plant them, or maybe I did plant them, but if I planted them, they come back year after year without recultivation every year. So these are what I'd refer to as your perennials, your trees, your bushes, your lawn. These are what we consider to be fructus naturalis. But look at the important point. These are real property. Now, here's why this is important. When I sell you my property, I shouldn't have to tell you, you get the oak tree, you get the lawn, you get the azaleas. If they're planted in my ground and they're growing, then you do get them as a matter of course. Fructus naturalis, perennials, they come back year after year without cultivation. They are real property. We don't even have to discuss it in the contract. Okay. Let's compare that to fructus industrialis. Now, and again, I don't know if that's the correct pronunciation or not, but looking at the word fruits of industry. Hey, I got an easier one for you. Think about crops. Okay. Now, definitions here. So vocabulary might be important to help you on the exam. Oh, by the way, this will be the first time I've said this, but there are a lot of vocabulary words on the exam. Here's an example of one right here. Emblements or implements, depending on how you would like to pronounce that. You're also later going to hear about things like easements and escrow and SG, a lot of the E words. Make sure you study those. They don't mean anything close to the same. I'm just warning you. There's a lot of E words, a lot of M words. Fructus industrialis, crops growing in the field. Now, again, in North Carolina, we deal with this on a fairly regular basis because you plant something in one season, you harvest it in another season. Now, notice what it says here on the slide, and this is what's important. One definition of implements, crops, means that it's an annual. It's something that comes back, it's something that you have to plant every year. If you want to reap it, you have to plant it. And so in North Carolina, the way that agricultural law looks at this, it says, he who planted it has the right to reap it. So let me give you a couple of advanced scenarios of this. Tenant farming is still very, very common in North Carolina. Well, at some point, your tenancy is going to expire. And if your tenancy expires, you may have a crop in the field. But here's what North Carolina law says. If you planted it, you have a right to reap it for one growing season. Okay, doesn't give you rights beyond that. And by the way, if I own the property and you have a crop in the field, I have to give you the right to cross my property to get the crop. Okay, if I sell you my farm and my corn is, if I sell you my farm, my corn's still growing in the field, I would have a right to come back and reap that batch of corn. Not next year, that's yours. Okay, but when we talk about fructus industrialis, we're talking about annuals, things that have to be cropped every year, have to be harvested every year. And we refer to those as personal property. The person who planted it has a right to reap it. Okay. Now, the word implement actually has two definitions. One definition is just the crop standing in the field. The other definition of implement is, in fact, a description of the right that you have to come back and reap what you have sown. Okay, let's recenter on this. Do you understand the difference between fructus naturalis and fructus industrialis? real property versus personal property. This is a real estate exam. So the only thing that's important in our mind is that what's going to happen when you sell the property. Fructus naturals stay with the property. Fructus industrials, you can go back and reap them if necessary, unless the contract says otherwise. And we'll talk about that a little bit later as well. Wrapping up this particular slide, if you ever hear me refer to the word severance or annexation, I want you to understand what they mean. To sever, just like to cut off, severance means to remove something from the property, to take a plant from the property. Hey, I want to keep my azalea bush. Is that okay with you? Sure, we'll put it in the contract and you can sever that azalea bush. Hey, I want to keep my ceiling fan in the dining room. Is that okay with you, Mr. Buyer? Sure, you can sever it from the property. The word annexation means attach. Annexation means you have attached something to the property. In other words, when I bought the ceiling fan at Lowe's, I then came and attached it to my property. I annexed it to the property. Keep your eye on how that affects real property rights in these. We're very, very close to addressing that. Okay. I want to not pause, but slow down here for just a moment, okay? We're about to reach the first level 3 testable topic on the exam when we talk about fixtures. Now, Lisa, I am looking at where you're sitting right now, and give me an example. I think you're in the dining room. Is that correct?
Yes.
All right. I want you to look around that room and tell me if there's anything that you would consider to be a fixture in that room.
And we have a light, a chandelier per se.
We have a chandelier in that room. And what's funny about it is this is literally day 1 of a pre-licensing class. And in the field, the chandelier is probably the most common mistake that people make when it comes to fixtures. So I slowed down to let you guys get caught up here so that we can identify that when we're talking about fixtures, this is the first level 3. What level 3 means is when you go out and start practicing in the field, you should know how to do it on day 1. You should know how to explain it to your clients, and you should know how to make critical decisions related to fixtures. Having said that, let's back up and let's give a definition. A fixture is an item that was once personal property that has become real property by virtue of its attachment to the property. So Lisa, let's say, for example, that beautiful chandelier. Matter of fact, where did we buy that beautiful chandelier?
I'm sorry, what did you say?
Where did we buy that beautiful chandelier?
Well, it wasn't inherited. It's not an antique. I believe it came from Home Depot.
I believe it did come from Home Depot as well. And when we bought it, it was in a box, right?
Yes.
And we threw it in the back of my pickup truck. And when we threw it in the back of my pickup truck, it was just personal property, right?
Yes.
But then we came home and we attached it to that ceiling where it is right now, what we just described as being a fixture, correct?
Correct.
All right. So let me ask you this question, Lisa. When I describe something as a fixture, is it real property or is it personal property?
It is real property.
Yes. By the time you define it as a fixture, it is real property because now that it's attached, it's real property. So that shows you how a property can go from being personal property to being real property by virtue of its attachment. Now, in regards to fixtures, one of the things that you're going to do, and I'm sorry, I'm going to have to look away here for just a moment because I'm looking at the offer to purchase and contract. If you're following along on your using the Dearborn materials, there is a hot link in there which will take you to this contract. So when I teach my classes, one of the things I always talk about with my classes or try to express to them is if you're trying to determine whether something is a fixture or not, the first thing you should do is look at what the contract says. If you want to know whether something is a fixture or not, look at what the contract says. Let me give you an example of why I think that's important. Some people will say, well, a fixture is, I've heard people say this one, for example, if you took the house and turned it upside down and shook it, whatever doesn't fall out is a fixture. Think about what they're saying. What they're saying is it's obviously attached to the house if it didn't fall out. The problem is that's not always correct. So what I do is I go to the contract, and I'm going to give you some examples of these, and some of them you're going to say, oh yeah, that makes perfect sense. Oh yeah, that makes perfect sense. But on a couple, you may say, well, I didn't know that. I didn't realize that was the case. So I'm going to read you a few things that our contract says is a fixture. Alarm and security systems, but parenthetically beside that, it has attached. In other words, they're attached to the house, and it gives a list. They could be for security, fire, smoke, et cetera, et cetera. If they're attached to the house, the buyer has a reasonable expectation that they're going with the house. But let me tell you to be careful. You need to make sure that these systems are owned by the seller. If they're leased by the seller, he doesn't own them, so he doesn't have a right to convey them. So you would need to express that. But the contract says if they're attached to the house, they go. Ceiling and wall attached fans. Ceiling fans, the one we discussed a little bit earlier, if it's attached to the property, it is in fact considered a fixture. Very, very easy. Light fixtures, they of course are fixtures as well. But I want you to listen to this for just a second. Fireplace insert, gas logs or starters, attached fireplace screens, wood or coal stoves. Now, that just said anything having to do with my fireplace basically is a fixture. Now, why do I mention that to you? Well, here's why. Many of the things it talked about are in fact attached to the house. It said attached screen. Okay, that's attached. It gave it away. The fireplace insert, a lot of times it's attached by a pipe coming in. Okay, but how about your gas logs? If you've never looked at your gas logs technically are not attached to anything. You could take them out, you could change them if you want to put some fresh ones in there. That's easy enough to do. But having said that, the contract says that the gas logs are a fixture, even though they're not technically attached to anything. Let me give you another example of that. Your garage remote control. You know that remote control that you have where you push the button to open up the garage door when you come home? It's not physically attached to the house. If you turn the house upside down, it would fall out, right? But it's a fixture because the contract says it's a fixture. Okay, here's your assignment. When it comes to fixtures, I need you to take the time to read that paragraph. It's in your reading, so just go over it, not to memorize, but to familiarize. And here's my point. You can determine whether something is a fixture. If the contract says it is, then by God, it's a fixture, unless the buyer and seller reach an agreement to the contrary. Okay, Lisa, does that make sense to you so far? In Chris' world, what's the most important determining factor of whether an item is a fixture or not?
If it's in the contract.
Thank you. Thank you. Read your contract. And if it says it is, it is. Now, the reason I mention that to you is as we continue on and go to B on this page, there's actually a test for determining whether an item is a fixture or not. However, if it's spelled out in the contract, you don't have to worry about this legal test. Matter of fact, oftentimes this legal test comes up if it ends up in court, and you do not want to end up in court because you made a mistake on a fixture and end up costing you some money. As you read through your book or through your course, you'll actually notice that the paragraph underneath this part actually says courts have not been consistent in applying the total circumstances test. So if you don't want to worry about what the courts are going to say, just make sure the contract's clear, okay? But if the contract is ambiguous about whether an item is a fixture or not, let's take a look real closely at the total circumstances test. I used to be able to say with confidence, you will absolutely be tested on this. I think you will in some way, shape, or form, but it's not quite as straightforward as what it used to be. Total circumstances test will determine whether an item is fixture. If you like mnemonics, this is one of the most popular ones in real estate. It's IRMA, I-R-M-A, and here's what it stands for. To determine whether an item is a fixture, what was the intention of the person who attached it? Did they mean for it to be permanent, or did they mean for it to be temporary? Let me give you an example. Young couple, just married, they buy their first home together. They buy a 3-bedroom, 2-bath. It's 1,300 square feet. It's perfect for them. They believe that they're going to live there forever. Well, that's nice, but naive. Okay. So thinking they're going to live there forever, they go out and buy each other for their wedding present a corner hutch where they can put all of their fancy china and stuff like that. It's a display case. It fits in the corner, and they say, you know what would make it look really nice? What if we took some chair rail molding and put it around the middle? If we put some crown molding at the top? Lisa, if they put chair rail around that corner hutch, if they put crown at the top, it starts looking like a what starting with the letter B?
Starting with the letter what? B?
B. B as in built in. What does it
Oh,
look like?
built-in. Well, I was thinking fixture, but built-in.
Yeah, yeah. And technically they're the same thing in this particular case. So what's going to happen in this case is it looks like it's built in to that wall. Well, here's what's going to happen. 5 years down the road, because statistically speaking, when people buy their first home within the next 5 years, they're probably going to sell it and move up. They had a couple of kids, they need 1,800 square feet instead of 1,300 square feet. Okay. So they sell it. As the buyer, when the buyer goes under contract and they come through to do the walkthrough, they look in the dining room and they say, wait a minute, something's missing here. They took the corner hutch. Well, here's the problem. If they were going to take that corner hutch, they should have told the buyer and negotiated that with the buyer. Because as Lisa just described, that built-in is probably going to be considered a fixture according to this rule. Because when they put the chair rail on it, when they put the crown on it, it looked like they meant it to be intentional. It looked to be permanent. Okay. So the question was, what was the intention of the attacher at the time of the attachment? If it's meant to be permanent when it was attached, you need to consider it a fixture when they later get ready to sell the property. The R stands for relationship of the attacher. Now, I'm going to make this very, very simple and not spend a lot of breath on this. Think about the difference between an owner versus a tenant. If an owner attaches something to the property, it's probably going to be considered to be a fixture. But think about a tenant. They're only there for a year or two or something to that effect. If they attach something to one of the walls, well, let me give you an example. One of my tenants actually wanted to have a ceiling fan in his bedrooms. And the reason he wanted a ceiling fan is he wanted to keep costs down. He liked the feel of a ceiling fan, et cetera, et cetera. I didn't put them in. He wanted to put them in, and he put them in with the understanding that when he left, he was going to take them with him. So what happened is when we listed that property for sale, what we did is we just simply informed the buyers the ceiling fans are not, in fact, part of the sale. Why? Because I don't own them. I can't sell them. My tenant owns those. So relationship of the annexer, was it the owner or was it the tenant who made the attachment? Think about it that way. You'll be fine. Method of attachment. This can be a little bit tricky, but here's good news for you. We have to write the test in a way that it's definitive, not ambiguous, okay? So we are not going to try to trick you on this. But the method of the annexation, was it bolted into place or was it just on a little nail or a 3M sticker? So think about the difference here. If I have a big screen TV and I have one of those wall mounts that I put it on, that wall mount better be screwed into a 2x4 stud in such a way that it indicates permanence. That's probably going to be a fixture. On the other hand, the pictures of my family, I just got them on a little tack or on a 3M. Nobody thought that the pictures of my family were going to be fixtures. The TV bracket, yeah, fixture. The little pictures that I have hanging of my family, yeah, probably not. And by the way, we're not going to get into this discussion right now, but I will tell you in the field, you better be careful about that TV that's mounted on that permanent mount, because some buyers may consider that to be real property. And the seller may say, oh, no, I never meant to sell that. What I meant to sell was the bracket, not the TV. Weirdly enough, there could be compelling arguments on either side of that. We won't go into it in this particular setting. And then finally, the A of the IRMA test was going to be adaptation. In other words, was it so customized that it makes sense that it was a fixture? Let me give you a great example. We actually had this case come on when I was a broker in charge. Our buyer was buying a property that had a large 2-story foyer, and this large 2-story foyer had large windows in the front, and the drapes that covered those windows were 2-story elaborately designed drapes. And so what happened was the buyer bought the property, and the understanding from the buyer was that the drapes were going to come with the property. Now, it's rare that drapes do. Typically speaking, the window hardware does, but not the material itself. However, in this case, here's what our argument was. Those windows that are 2 stories, these are custom-made drapes to cover those windows. The only thing that makes sense is if they stay. What happened was the buyer and seller ended up in a squabble, and the seller said something to the effect of, I'll show him, I'll take those damn drapes down, and they're going to have to go spend $2,000, $3,000, $4,000 to get their own drapes made for that. We ended up, cooler minds prevailed, and ultimately the seller said, all right, I'll leave the drapes, because he thought he would not win if this were to go to court. So adaptation, was it so customized that the only thing that makes sense is for it to stay? All right. Do yourself a favor. Don't allow Irma to be your deciding factor as to whether an item is a fixture or not. Write it in the contract so that it's unambiguous, and make sure that the clients understand what's going and what's staying. Weirdly enough, if you do reach the total circumstances test, the most important determining factor would be the intention. Number one up there, the intention of the attacher. Okay. Fixtures. You're going to want to make sure you spend time with this slide, with your book, and with test questions associated with fixtures. I promise you it's going to be your first level 3 test question. Okay. All right. Let's drop back the intensity just a little bit. Closely associated with fixtures is going to be the concept of trade fixtures and agricultural fixtures. Okay. But let me just go ahead and cut to the chase when we come to trade fixtures. Look at the name of it, trade fixtures, a fixture that's used in conjunction with your practice of a business, with your trade. Okay. And here's the rule. When you leave, now think about it, a trade fixture, when I had a retail store, we had a lease that only went a certain number of years. So when we left, here's the rule. If it was something that we attached to the property for the conduct of our business, then we could take it with us when we leave. So trade fixtures, you can take them with you when you leave, if you'll do it, 1, before your lease expires, and 2, if you will repair any damage that you did to the property. Now, for example, when we're talking about trade fixtures, there are some things that the landlord did, some things known as upfits. An upfit is something that the landlord does to make the property more usable. A lot of times when you're renting commercial properties, you rent what's known as a plain vanilla shell. And then between the landlord and the tenant, you upfit the property for what you're going to use it for. So if the landlord built you in a lighting array, if the landlord put in carpet, if the landlord constructed walls for you, well, they're going to be fixtures. On the other hand, if you came in and put shelving for shoes and clothes and stuff like that, those are trade fixtures. So let me go over a couple more with you just real quickly. What if you had a pizza restaurant? Well, in my pizza restaurant, I'm going to have a bar. I'm going to attach it to the wall and I'm going to attach it to the floor because I don't want people knocking it over and getting hurt. But it's still mine. That pizza oven, I'm going to bring it in. I'm probably going to bolt it to the floor, to the wall, so it doesn't tip over when we're cooking and moving pizzas. OSHA might require it. Okay. But it's a trade fixture. On the other hand, take that same pizza oven. If it were so large that it were bought in and constructed on site and built into the concrete, well, that would be different because it's immovable at that point, and it would become part of the landlord's property after that point. So here's the rule. Trade fixtures, you attached it to the property for the use of the conduct of your business. Take it with you when you go. Do it before the lease expires, and also repair the guy's property, and you're fine. Similarly, or actually just the opposite, agricultural fixtures in North Carolina are considered to be real property when you attach it. So to make this very simple is, if you are a tenant farmer and you attach something to that farm, be prepared to leave it when you go. I actually don't lose a whole lot of sleep about this, and here's why. First of all, if you've ever seen an agricultural fixture, a lot of these things are huge. It may be a large trough for feeding animals. It's heavy, it's difficult to move. When you buy it, make sure that you have calculated that into the cost of doing business, because you're going to leave it when you go. Have you ever seen a silo, a big metal building? Good gosh, you're not going to break it down and take it with you when you go. So agricultural fixtures, they're going to stay on with the property when your lease is over. Okay. Fixtures, big deal. Trade fixtures, you know what? Take them with you when you go. Agriculture fixtures, they stay on the property. Not a whole lot to know beyond that. Maybe a couple of examples, but beyond that, not a big deal. Okay. Lisa, do you have any questions or comments so far? Anything you can remember from the exam that you would like to talk about in regards to fixtures?
No, I don't think so. Like you said, what's in the contract, what's named specifically. I think that's very important to remember that.
Yeah, would it be safe to say that when you took the exam, they didn't really try to trick you on this? You just had to be pretty knowledgeable of it?
I think so. You have to be familiar, I would say, be familiar with your definitions and specific examples that you have and try to make sure you read through carefully.
Yeah, I tend to think that the ones at the end of the chapters are probably a little more tricky than the exam is, because, like I say, on the final exam, they have to be done in such a way that they're not ambiguous. Okay, so yeah, well, what Lisa said, go to the contract, not to memorize, but to familiarize, and you're going to be fine. I give you an example here, and because you don't have the same slides I do, I'm going to sit here for just a moment, and we're going to talk about trade fixtures and how they're going to work. So, a pizza parlor leases space in a small shopping center. The restaurateur bolts a large iron oven to the floor of the unit. When the pizza parlor goes out of business or relocates, the restaurateur will be able to remove the pizza oven if the bolt holes in the floor can be repaired. The oven's a trade fixture. On the other hand, if the pizza oven was brought into the restaurant in pieces, welded together, set in concrete, in that case, the oven might be a fixture. This was the example I gave you just a moment ago. Okay. And then wrapping up, fixtures should be clarified when property is listed and the sales agreements negotiated. So look at what it's saying there. Two things that we've already talked about. The first one is this. You know, when your first opportunity to talk about fixtures with clients is, how about when you're getting the listing agreement? Go ahead and have that discussion with the seller. That'll be fine. And then when you get ready to write the contract, make sure the buyer and seller are on the same page. And later, when we study the offer to purchase contract, here's the deal. If you are absolutely attached to that chandelier in your dining room, if it's an antique, if it's a family heirloom, I have two pieces of advice for you. One is you could take it down before you ever show the property. If it's not there, the buyer has no expectation of getting it. Or two, make sure you write it as an exception in the contract. And you'll see this in chapter 10, where the contract is built that says, hey, would you like to exclude any of these items that are meant as fixtures? And if the buyer says, or if the seller says, I want to exclude that chandelier, then the buyer knows if they enter into the contract that they're not getting it. Okay. And then just a quick bullet point on the effect of the North Carolina Uniform Commercial Code. Now, in real estate, if we have the opportunity to shorten something to an abbreviation, we almost always do. So you'll probably hear me refer to this as a UCC filing, okay? Stands for Uniform Commercial Code. All right, good news, bad news. Bad news about the Uniform Commercial Code is it is a dense set of uniform laws on that control business transactions, negotiations, contracts, and things like that. None of which I care about except for its effect on real property. So all you need to study is the UCC's effect on real property. And here's the way I think of this. The UCC's effect on real property is an item that appears to be real property remains personal property as long as it's financed. So it remains the personal property of the financier. Okay, by all rights, when you look at it, it appears to be real property. Let me give you an example. Okay, my HVAC system, my heating, ventilation, and air conditioning system. Okay, I had to have a new air conditioning system put in, and I didn't have enough cash. So what did I do? I financed it. And the guy said, you know what, Chris, I'll put the air conditioning system in today. You can start using it immediately, and you can pay me over time. That's good news because I don't have cash. But he made me sign two documents when he did that. What he made me sign were a financing statement, which is I owe him money and I'll pay him back on these terms. Okay. He also made me sign a security agreement. That security agreement was taken and it was recorded at the Register of Deeds. And what it basically says is, hey, the financier has a security interest in that air conditioning system. If Chris stops paying us, we're going to come take the security system, the air conditioning system. By the way, let me slow down here for just a moment. I want you to notice on a UCC filing, if I stop paying for the air conditioning unit, the only thing they have a right to come and collect is the AC unit. In other words, they don't have a lien against my house, they have what we refer to as a chattel mortgage. If you'll remember from chapter 1, chattel meant personal property, chattel mortgage. Okay. So if they file that security agreement and I stop paying them, that security agreement gives them the right to come get the air conditioned, nothing else but that. So what's the effect of the UCC filing? An item that appears to be real property remains personal property of the financier until the financier is paid off. Good news. Notice I said it's recorded. And so any attorney that's doing a title search would find and discover this, and they'd say, hey, seller, do you realize you still owe somebody $2,500 on that air conditioning system? And normally what would happen is they would resolve that at the settlement table at that time. Title search should reveal any such disagreements. Effect on UCC, let's treat that as a level 1 and move on. Okay, we have a few questions here at the end of this little chapter. Lisa, my voice is getting tired. Can you read these questions for me, and then read the answers one at a time, and we will discuss whether they're right, wrong, and why I asked the question in this way. Go.
Okay. Sue Seller, an award-winning gardener, sells her home to Betty Buyer and plans to close on June 6th. When Betty does her walkthrough, she sees that Sue has removed the azalea bushes from the front of the home. Sue explains that because she is noted for her gardening, she rightfully took her favorite azalea plants that she nurtured for years. Betty is distraught. Which of the following is true?
Okay, so the first one says, seller may keep the plants because it was never her intention to leave her prized bushes. What do you think, true or false?
I would say false.
That is false, because do you remember the word for this? Items that are growing in the ground that don't require cultivation.
Naturalis.
These are your naturals. These are your perennials. They're coming back year after year. They're real property. They go with the property. If Sue wanted to keep it, she should have said that she was going to take them. Okay. All right. So then the next one says seller must return bushes because they're considered real property. What do you think about that one? Okay. Don't answer yet. Let's take a look at the other answers. It actually sounds okay so far, doesn't it? It doesn't sound wrong. So let's keep that one in mind. Let's take a look at the next one. Oh, this is one of those one only, two only, both or neither. Okay. Well, we've already said that one was incorrect. So now let's look at two. I think two sounded okay. I got to be honest with you. In real life, rarely do they bring the bush back. Normally what they do is pay a fee for having taken it. But two is technically correct. So the answer in this case is the second bullet point. Two only would be correct. Here's good news for you, those of you playing at home. We have been told that they don't ask very many of these questions, one, two, both, or neither, on the exam. They have removed most of these from the exam. It's still possible that you may get one, but they've tried to remove these from this format from the exam. Okay. Now, let me tell you why I wrote this question. Notice the way I set it up. Sue Seller, an award-winning gardener. And what I'm trying to do is get someone to think, oh, come on, she put so much work into those plants, she should get to keep them. Doesn't matter how much work she put in them. Doesn't matter how sentimental. It doesn't even matter the value of these plants. All that matters is whether they're fixtures or not. Okay? Questions or comments on that, Lisa? You feel pretty good about that one?
I think so.
Let's try the second one. You read.
Jim recently contracted to sell his house. His contract had no exceptions regarding the fixtures provision. On his property, he grew Japanese maples and other ornamental trees that he had cultivated for years. He also had a small but very valuable chandelier that he had inherited from his grandmother hanging in his dining room. The house also had custom blinds that would fit perfectly in his new home. Which of the following statements regarding this scenario are true?
All right, so let's look at number one. Jim can take the Japanese maple because they were planted and cultivated by Jim. What do you think? Yes or no?
I think no.
Nope. If they're planted in the ground, he can't take them. Two, he can remove the chandelier as long as he does it prior to closing.
Not if it's not written in the contract.
Yeah, but I was tricky there. You know, if he had taken it down prior to showing the house, it would have been one thing. But prior to closing, no. Sorry about it. And notice I tried to pull the heartstrings on that. He had inherited it from his grandma. Doesn't matter. It's still a fixture. Jim can remove the custom blinds since he could use them in his new home.
I'm not quite sure. Would those be considered hardware?
Yeah, these absolutely, in this particular case, your hardware is going to include your blinds. It's also going to include your, what are those things called? That you,
Curtain rods,
yeah,
the
it
rod,
includes curtain rods. What's the word I'm trying to think
like
of?
the shutters, like plantation shutters.
Yeah, yeah, stuff like that. All of those would be considered window hardware. Outside of the material for the drapes, most everything else does, in fact. I've actually had cases where people tried to take the curtain rods because they matched a baby's decorating pattern in their room and they're going to take it to their new house, but it's window hardware, so that he can't take it. And then finally, number 4, all items will convey with the property according to the contract.
Yes.
Yeah, all those are going to convey unless he says otherwise. And notice in my setup, I didn't say that he said otherwise. Okay. And then finally, you go ahead. You read this one.
The owner of a large tract of land places the property on the market to sell. 2 years earlier, he had entered into a lease agreement with an oil company to remove the oil from the property. The term of the lease was for 40 years. The oil company did several tests and determined that it was not currently feasible to drill. Which of the following is true?
All right, let's look at A here. The owner could not lease the oil rights because they were inseparable from the property. Is that true or false?
That's false. They are separable.
Yeah, appurtenances are separable rights. I can't always tell you they have value. In this case, they did. So yes, they're separable rights. So that's not true. The owner cannot convey the tract of land because of the encumbrance of the mineral lease. What do you think about that one?
I think he can. The potential buyer would just have to know about the encumbrance, that there is this lease for 40 years.
Yeah, not true. He can convey it subject to the lease. Very good. True or false? The owner can convey the tract with the buyer taking the title subject to the encumbrance of the lease.
True.
I like that. So let's read D just to make sure that we didn't miss something. None of the above is true. Well, we know that's not true because we know that C is in fact true. So my answer to this question is in fact C. Okay. All right. Let's stop at that point. What we did today, we talked about appurtenances pretty deeply. And then we talked about fixtures, out of which you absolutely know that you're going to get test questions. So we've done the heavy lifting under the concept of property. When we come back for the next slide, we'll talk about a couple of other things closely associated, but on a much lower level. Okay, so that's a wrap for fixtures for today. Lisa, do you have any questions before we stop the recording?
No, I don't think so. Just remember, if he says it's important, it's important. That's one of the things I learned from taking his class.
Perfect. All right. We'll see you tomorrow.